ever get that feeling? Like you really want to dive deep into something important, wrap your head around it,
Yeah.
really get it, but you're slammed. I mean, who's got time to wade through pages and pages of dense legal documents?
Right.
I hear you. So that's exactly where this deep dive comes in. Think of it as a fast track to understanding something absolutely crucial, the legal side of child abuse reporting here in California.
Huh.
Specifically, we're going to laser focus on the ins and outs for those folks known as mandated reporters. We're working off that child abuse reporting document you sent over.
Exactly, and it's such a heavy topic, so we're aiming for clarity here, real clarity. By the end of this, you should have a rock-solid grasp of who's legally required to report, what actually constitutes reportable abuse and neglect, and the step-by-step process for making those reports. All of this, by the way, is rooted in the California Child Abuse and Neglect Reporting Act. Legally speaking, that's California Penal Code sections 11164 through 11174.3.
Okay, so right off the bat, we bump into this term mandated reporter. What exactly does that mean in this context?
Well, the document lays it out pretty clearly. A mandated reporter is someone whose job, their profession, puts them in a position where they are legally obligated to report any suspected child abuse or neglect. It's not a should do, it's a must do. And as the source makes clear, this absolutely includes psychologists, which I know is particularly relevant for you.
Are sure?
Now, it's important to note that this legal obligation also extends to minors who are emancipated, those who have the legal rights of an adult. And critically, this duty to report, it applies regardless of whether the suspected perpetrator is an adult or, get this, another child.
Wow, that's a really important point. It's not always a clear-cut adult-on-child scenario.
Yeah.
So let's talk about the when of all this. When does this responsibility to report actually kick in? What triggers it?
The document points us to PC section 11166A. The key here is when a mandated reporter in their professional role or within the scope of their work sees or learns about a child they either know or reasonably suspect has been abused or neglected. And get this, the law says they have to make an initial report immediately or as soon as practically possible, and they have to do it by phone. Then, within 36 hours, a written report needs to be submitted that can be mailed, faxed, or sent electronically. Oh, and it can also include any relevant, non-privileged documentary evidence they might have.
Okay, so you just said reasonably suspect. That phrase, it seems like there could be some wiggle room there. Like,
Yeah.
What exactly does that mean legally?
Yeah, you're right to pick up on that. That's a super important question. Reasonable suspicion actually has a legal definition. It means that, based on the facts, it would be objectively reasonable for someone to suspect abuse or neglect. Someone in a similar position using their professional training and experience. So it's more than a gut feeling, right? It has to be grounded in something observable. Interestingly, the document specifically says that just because a minor is pregnant, that alone doesn't mean you automatically have reasonable suspicion of sexual abuse. It's a clear boundary the law sets.
That's really helpful to know, a very specific clarification. So we've got the when nailed down. Let's talk about the how now. What are the actual steps involved in making a report?
Like we touched on, PC Section 11166A breaks it down into two steps. First, there's that initial phone call. Gotta make that right away as soon as you can. Then that's followed up by a written report within 36 hours of getting the information that raised your concern. Like we said, the written report can be mailed, faxed, or sent electronically.
Pretty straightforward. But what happens if multiple mandated reporters are involved? Let's say a whole team is working with a child and their family.
Good question. Section 11166 actually addresses that scenario.
Yeah.
So if you've got a group of mandated reporters who all know or suspect abuse or neglect, they can decide amongst themselves who's making that first phone call. Then just one person writes up that detailed report and everyone signs it. But, and this is huge, if anyone in that group finds out that the designated reporter didn't make the report, well, they're now obligated to do it themselves. It's a fail-safe, Everyone's ultimately responsible.
That makes total sense. Prevents people from assuming someone else took care of it. So who are these reports actually sent to? Who's on the receiving end?
Section 11165.9 tells us exactly where those reports need to go. First, you've got your police departments, like city police or the county sheriff's department. But here's a little curveball. This specifically excludes school district police or security. Then there's the county probation department, but only in counties where they've been specifically designated to take these reports. And finally, and probably the most common, the county welfare department, which, as the document points out, can also be called the County Welfare Service Agency or CPS Child Protective Services.
Got it. Okay, so that's the who and the how. Now for the really big question, What exactly are we talking about reporting? What actually constitutes abuse under the law?
So the legal stuff that makes it mandatory to report,
Hmm.
PC section 11165.6 spells it out. First up, physical abuse. Legally speaking, that's any non-accidental physical injury inflicted on a child by someone else or even death. Now, there are some specific exceptions, like fights between minors, if it's mutual, and then reasonable and necessary use of force by law enforcement, when they're doing their job.
So basically intentional harm from an adult or another child with some specific carve-outs for those situations with minors and law enforcement. What's next on the list?
Next, we've got sexual abuse. This is a big one, covered in PC section 11165.1. It includes both sexual assault and sexual exploitation. Sexual assault covers things like rape, statutory rape, rape in concert, incest, sodomy, lewd or lascivious acts, oral copulation, sexual penetration, child molestation. And then sexual exploitation includes things like creating, selling, or distributing child porn. Using a child in obscene acts, prostitution, live obscene performances, even depicting, downloading, streaming, duplicating, printing, or accessing child porn. All big no-nos. If you suspect any of this, you're mandated to report.
Wow, that's a really disturbing and broad range of actions. Now, I noticed the document mentions some specific considerations when it comes to non-intercourse sexual acts. What's the deal with that?
Ah, yes. This is where it gets a little tricky, so pay attention. Generally, non-intercourse sexual acts, if they're consensual and there are no other signs of abuse, they're not something you have to report. But, and this is a big, but if you have someone who's 21 or older having any kind of non-intercourse sexual contact with a minor under 16 and it wasn't consensual, that must be reported no matter what, even if the minor says they consented. And this applies regardless of the adult's age. Same goes for any lewd and lascivious acts between someone under 16 and someone 21 or older. Always reportable. Now, in other situations with minors, it really comes down to professional judgment. Assessing consent, looking for exploitation, considering your overall duty to report. Age is a big factor in these less clear-cut cases.
It sounds like that age difference really comes into play in those trickier situations. So what other types of abuse are we obligated to report?
Okay, next up is willful harm or injury. PC section 11165.3 spells this one out. Basically, this is when someone intentionally hurts a child, physically or emotionally. Or if they're supposed to be caring for the child and they put them in a dangerous situation. One important note here, the document specifically says that fetal abuse isn't considered reportable child abuse in California. So therapists need to know that and maybe consider other options if they're concerned about an unborn child.
Good clarification. That's a pretty significant distinction. Now, what about when it comes to disciplining kids? Where's the line between acceptable discipline and reportable?
That falls under unlawful corporal punishment or injury, which you can find in PC 11165.4. It's basically when someone intentionally uses cruel or really inhumane punishment on a child that ends up causing a traumatic injury. There are some exceptions, though. Like if school staff use reasonable force to break up a fight or for self-defense or to take away a weapon, that's okay. Also, reasonable and age-appropriate spanking on the butt, without causing serious injury, is also excluded. This is actually in Welfare and Institutions Code, Section 300A. So it really comes down to whether the punishment crosses the line into something cruel, inhumane, or causes actual physical trauma.
So it's about the severity of the punishment and the harm that comes from it. Makes sense. Now, the last category on the must-report list is neglect. That seems like a pretty broad term.
You're right, it can be. PC section 11165.2 defines it as negligent treatment or maltreatment of a child by someone who's responsible for them. And it has to be under circumstances where it's clear the child is being harmed or is at risk of being harmed. This includes both doing something harmful and failing to do something that's needed. Now, there are two types of reportable neglect. Severe and general. Severe neglect is specifically when a caregiver doesn't protect a child from severe malnutrition or something called non-organic failure to thrive, which has to be medically diagnosed. General neglect, on the other hand, is when a caregiver doesn't provide enough food, clothing, shelter, medical care, or supervision. But, and this is a big one, thanks to Law AB 2085, general neglect only applies if the child is in serious danger of being hurt or getting sick. The law specifically says that a parent struggling financially doesn't automatically mean general neglect. Also, if a child is getting spiritual treatment or not getting medical treatment for religious reasons, that by itself isn't neglect. And lastly, just leaving a kid unsupervised isn't always neglect, unless it puts the child in actual danger. Lots of nuances here.
Those are really important clarifications, especially about financial hardship and religious beliefs. Seems like the law is really trying to be specific about what is and isn't neglect. Now, the document also mentions situations where a mandated reporter may make a report. What falls into that category?
Right. So PC Section 11166.05 deals with that. This is for situations where there's serious emotional damage happening or a high risk of it. You might see things like extreme anxiety, depression, withdrawal, or aggression, either towards themselves or others. In these cases, the mandated reporter can choose to report it, but it's not a must, like the other types of abuse we've talked about. It's left to their professional judgment based on the situation.
Okay, so it's about serious psychological distress, but it's a judgment call, different from the mandatory reports. Now, switching gears a bit, what about sharing confidential information? Can mandated reporters do that if it relates to potential illness?
They can, but it's very specific. Welfare and Institutions Plan, Section 830A, allows people on something called a multidisciplinary personnel team. You know, the folks involved in preventing, identifying, managing, or treating child abuse and neglect. They can share relevant information with each other. And this can include things that are usually confidential, like stuff from juvenile court records, as long as they believe it's relevant to the case or to providing child welfare services. It's important to note, though, that whatever they discuss in these team meetings is confidential, unless a court orders them to disclose it. And they can't be forced to testify about these discussions in court. It's a way to help them work together better while still keeping things private.
It sounds like it's all about improving communication and coordination between the different professionals working on these sensitive cases. Let's talk about legal stuff now. What kind of legal protection do mandated reporters have? And what are the consequences if they don't report?
So there's good news for reporters. PC Section 11172A grants them immunity from lawsuits, both criminal and civil. And this applies even if they learned about the abuse outside of their professional role. Anyone who makes a good faith report of child abuse has this protection. The only exception is if someone intentionally makes a false report, knowing it's false or not caring if it's true. It's like the law is encouraging people to come forward.
Makes sense to have those safeguards. But flipping it around, what happens if a mandated reporter doesn't report when they're supposed to?
Well, that's where the penal code steps in. PC Section 11.1.1667 fee lays out the penalties. If you knowingly don't report suspected child abuse or neglect when you're legally required to, that's a misdemeanor. And it can get you up to 6 months in jail, a fine of up to $1,000, or both. And if you try to hide the fact that you didn't report, that's considered a continuing offense. It just keeps going until someone finds out. To make things even more serious, PC Section 11.166.01b says that if you intentionally don't report, or if you stop someone else from reporting, and that leads to the child dying or being seriously injured, you could be looking at up to a year in jail, a $5,000 fine, or both. And on top of all that, you could be sued and lose your professional license. No joke.
Wow, that's some serious legal trouble. Really highlights how important this obligation is. Now, a more practical question. Are mandated reporters required to tell their clients if they've made a report?
Legally speaking, no. Psychologists aren't required to tell the client they're making a report. But realistically, especially if the therapy is going to continue, it's usually a good idea to let the client know you're going to report, unless there's a good reason not to. Like if you think telling them might put someone in danger. A lot of therapists will actually put this exception to confidentiality right in their office policies or in the Notice of Privacy Practices, the NPP, that clients get when they start therapy. That way, if it comes up later, they can just remind the client. Of course, if the therapy continues after a report, the therapist might need to work on rebuilding trust with the client. It's a delicate dance between legal duty and the therapeutic relationship.
Absolutely. Transparency and keeping that therapeutic relationship healthy is so important. What about when an adult client discloses they were abused as a child? Does that automatically trigger a report?
Not always. As long as the person who is now an adult, a mandated reporter isn't usually required to file a report about that past abuse. However, psychologists should always be on the lookout for signs that the abuser might still be hurting other kids. If something comes up that makes them suspect that, like, if the client says the abuser still has contact with children, then they have to make a report. It's about protecting those who might be in current danger. If a psychologist isn't sure whether they have enough information to warrant a report, they can always call CPS anonymously and ask for advice. They can also talk to their client about legal options, like pressing charges or suing the abuser. But they should also explain the possible downsides of doing that and respect the client's decision. It's all about finding the right balance between supporting the client and fulfilling your legal duty.
Yeah, that sounds like a tricky situation to navigate, supporting the survivor while also being mindful of potential risks to other children. Now, the document also brings up cultural sensitivity. How does that come into play when professionals are trying to figure out if something's abuse or neglect?
This is so crucial for any mandated reporter. Psychologists have to be really sensitive to the client's culture and religious beliefs and practices. They need to understand that what's considered acceptable child rearing can vary between cultures. But, and I can't stress this enough, at the end of the day, they have to follow the California Child Abuse and Neglect Reporting Act. The document gives a really powerful example. Let's say a client admits to beating their child with a stick, bad enough that the child needed stitches, and the client says, well, that's how we discipline kids in our culture. Even with that explanation, the psychologist would have reasonable suspicion of abuse because of the physical injury and would be legally obligated to make a report. Protecting the child always comes first, even if it clashes with cultural norms.
That example really drives home the point that understanding cultural context is important, but it can't overshadow the duty to protect children from harm. Okay, last but not least, the document talks about situations where the psychologist learns about the abuse from someone other than the victim. Can you clarify when they'd have to make a report in those cases?
Absolutely. If a psychologist finds out about suspected child abuse while doing their job, for example, if a client tells them their adult son is physically abusing his child, they have to make a report, even if they haven't personally seen the abuse. The key is that they learned about it during a professional interaction. Now, let's say a psychologist overhears a conversation somewhere, like at the store, and thinks a child might be being abused. In that case, they're not legally required to make a report, but they are allowed to if they want to. The difference is whether they got the information while acting in their professional role.
So it really boils down to how they came across that information. Okay, let's recap what we've covered in this deep dive into California's child abuse reporting laws, specifically for those mandated reporters. We pulled directly from this document and the California Penal Code, and wow, there's a lot to it. Yeah. We talked about the when, which is immediately upon having reasonable suspicion of abuse, the how, an initial phone call followed by a written report, and the what, the specific categories of physical abuse, sexual abuse, with all those nuances around non-intercourse acts, willful harm, unlawful punishment, and both severe and general neglect. And, of course, those exceptions for things like financial hardship and religious practices.
It's amazing how detailed this legislation is, especially when you look at all the little distinctions between different types of neglect and all the exceptions, like allowing reasonable force by law enforcement, or that very specific situation where spanking's okay. Clearly, they put a lot of thought into defining these tricky situations as clearly as possible. It makes you appreciate the careful balance they're trying to achieve with the law.
Absolutely. It really begs the question, why is all this detail necessary? What does this complex legal framework tell us about how much California and society as a whole values protecting children? It's obviously a huge priority, with serious legal consequences for those who are supposed to report and don't.
And that leads to a really interesting question for everyone listening. Putting aside the legal stuff we've discussed about mandated reporters, what about everyone else? What are the ethical considerations for anyone who suspects child abuse, even if they're not legally required to report? What about our moral duty to protect kids? What role does that play in keeping children safe in our communities? Something to think about.